My name is Marianne Monteleone. I'm Vice President of Professional Development for LIBOR, and I welcome you. At this time, I'd like to introduce our presenters. Al Fazio, partner with Caputa, Fazio, and Giacoya, legal firm in New York City, New York, and our very own Patrick Fife, General Counsel for the Long Island Board of Realtors. I turn it over to you guys.
Okay, great. Thank you, Marianne. Good morning, everybody. Thanks for being here. It's a pleasure to be joined this morning by Al Fazio. For those of you that don't know Al, he has been a long time, he's an attorney, a long time instructor here with LIBOR, and he is also the voice behind the LIBOR Legal Support Center. So we've got an interesting hour planned for you. We're going to go over a lot of the calls that Al has been getting, the issues that are popping up here in the field, and hope to provide you all some timely information concerning a number of topics. One thing I just want to make sure that everybody is aware of before we do get started is how you can find LIBOR's Legal Support Center. We started the Legal Support Center earlier this year. You also still have access to the NYSAR Legal Helpline, but this is an exclusive benefit for LIBOR members. It's available 9 to 5. Can provide you general information concerning real estate matters, and it can be accessed through our normal regular LIBOR phone number, 631-661-4800, and it's extension 335. And Al is available 9 to 5, Monday through Friday, excluding holidays. So with that, we are going to get moving. Al, are you there?
As Patrick mentioned, I am honored and privileged to be the LIBOR Hotline attorney. It has been a good, I guess, 9 months now, and I look forward to speaking to as many of you as possible, not all at one time, hopefully. But as Patrick mentioned, I am available during the week to answer your questions. And I do want to make sure you understand, even though the voice message that you'll get from time to time says I'll get back to you within 24 hours, those of you who have called and left messages know that's more like 2 to 3 hours at most. So Patrick, take it away. Let's get started this morning.
All right, great. So we're going to try to keep this more conversational. We do have the slides. They will be eventually posted with the video from today's class to the website. So first question, Alan, and there's a reason why I'm asking this question. Is calling finally allowed in New York?
Well, Patrick, I'll say that we know that anytime a state of emergency is declared for whatever reason by the governor's office, it is automatically tied into cold calling. I can't necessarily indicate the reasons why. In fact, those of you who are going to the state meetings, I understand that part of that might involve some of this in lobbying the state legislature to try to get them to decouple the state of emergency from cold calling. What the relevance is difficult for me to understand. Nevertheless, that is how it works. And right now, there is a state of emergency in place, at least one of them, concerning public order at correctional facilities that's supposed to expire the end of the month, but it is always renewed. So you can go online and confirm that a state of emergency exists. You must be attentive to that. And if you didn't get that point, let me drive this home to you. Last week, I got a Department of State complaint from a client of mine that owns a pretty sizable firm. One of his agents allegedly had cold called and also used a vendor to contact sellers through the telecommunications, through automatic dialing. It was picked up and reported to the Department of State. The Department of State is now contacting, or I should say, has started a complaint against the brokerage firm and the agent, looking for damages of $13 million. That's $20,000 per violation. Every call you make that violates cold calling or the Telecommunications Act is $20,000 per occurrence. So if that doesn't drive the point home, I don't know what will.
Yeah, so that's the big reason why we made this the first question. A couple other things. One, please keep updated through LIBOR. We will let you know when cold calls are permitted again. And second thing is, you once they are allowed, there are specific rules that you must follow. Part of the complaint that Al was talking about not only was violation of that state of emergency and calling when you're not supposed to, but not doing it the right way. I don't want to confuse people. We don't want to go through all the steps that you need to follow when you make a call, but once calls are allowed again, we will put out all the instructions that you need to make sure you're following because this is something that's obviously on the Department of State's radar, and it needs to be on yours. All right, so next question. Is there a new property condition disclosure statement form, Al? I know you've gotten some questions over the last couple months about this.
Yeah, I think the questions we get is mostly is what is the agent's responsibility? Um, and many times when during our phone calls and conversations with the agents, I always go back and ask them about their office policy. What we know, what Patrick and I do, what might be best practices has to be able to jive with your respective office policies. According to New York State, we know that as an agent, you're required to inform the seller of the existence of the property condition disclosure statement, which was recently modified as of July 1st. You should be using the new form. Make sure you are using the new form. But that as an agent, your obligation is to disclose that it does exist and that the seller is required to provide one to a buyer prior to making an offer. When you're a buyer agent, a buyer rep, or even as a listing agent working with an unrepresented buyer, you need to inform the buyer that in fact they have a right to receive a property condition disclosure statement. So whether you choose to give it, I would say we're suggesting best practices is to give the seller the form at the time that you take the listing with other documents that you get the seller to sign, fair housing disclosure, agency disclosure, listing contracts, lead paint. It's a good thing to give the seller, give Mrs. Monicati, my generic seller, the form and tell her that she's going to need to complete it at some point. But you don't do that. You don't help her complete it. It's not your job to help her complete it. One more thing I do want to say, and I think this is also best practices. Depending where you practice, talking about Long Island, talking about Queens, talking about Brooklyn, any of the boroughs, attorneys take different positions concerning this property condition disclosure and the requirement to give it. The statute is clear, it's required. Some attorneys are in their contracts indicating that a buyer is supposed to waive it. I'm not going to get into that with you now. That's not what we're here for. But because sellers attorneys are doing that, the suggestion I make is when you speak with the seller about filling out the form, I would suggest that you say to the seller, Mrs. Monicati, before you complete the form, before we give it to a buyer, why don't you speak with your attorney and see what your attorney is suggesting, how and what's the best way to go about doing that? Some attorneys are telling their sellers not to provide the form. We believe that is a violation of the statute. Nevertheless, the attorneys have a relationship with their client, and I don't want to put the agent in the crossfire as having given the document out to the buyer if they're asked to do so. When an attorney might say to a seller, "Why did you give it to the agent? You shouldn't have done so." So the suggestion would be to ask the seller to speak to their attorney first.
I think that's a good suggestion, Al. I mean, I know you also sometimes get questions from buyer's agents saying, the listing broker won't give me the disclosure. My buyer wants to do their home inspection. I want it now. That's great. You want it now, and maybe the seller will give it to you, but legally they don't need to provide it until the time they provide that contract or prior to the buyer signing the contract. And that's why when you get into those issues, I agree with you. It's best to let the seller speak to the attorney, have the attorney's input about when is the best time to provide on that particular deal.
And you know something, Patrick? I think our members just need to understand something too. The statute was written, as you said, for the document to be given prior to contract. Well, when you're downstate like we are, it kind of doesn't make sense, right? Because why would I go through offer, acceptance, negotiation, do an inspection, and not have that form in front of me when I'm making my offer or having my inspection? And now I'm ready to sign a contract, and then I get the form that says there are defects, which is only going to cause it to go back into negotiation again and do a counteroffer. Remember this, downstate, we do things differently than most of the country and the state. Agents don't prepare contracts down here. When you go upstate or other parts of the country, the agent is preparing the contract when the offer is made. That is the contract. So it would be natural for the document to be given to the buyer before they're signing the broker prepared contract. We don't do things that way downstate. And that's why we're seeing lots of buyers who do ask the question, can I get this before I sign the contract, before I even make the offer to see what's existing? It doesn't mean you can't ask the question. It's up to the listing agent and the seller and the seller's attorney to decide if they want to give it to you at that point or just prior to contract. The statute does say prior to contract. And just quickly, remember, there are exemptions. If there's an estate sale, it's exempt. Trusts, if a trust is the owner, it's exempt. If there's foreclosure sale or a sale between parties who are owners, it's exempt. Condos and co-ops, exempt. So I do get questions about that, Patrick, as well.
Okay. Um, Another question I know that comes up about disclosure is I've got an interest in a transaction. I'm the owner of the property and I'm listing it. Do I need to make a disclosure? What disclosure do I have to make?
You're talking about material defects?
No, in terms of I own the property. I need to disclose when I have a ownership interest in a transaction?
Oh, if you're the agent, is that what you're saying?
Yes,
Yes.
yes, I'm the
Okay.
agent. Right.
Yeah, well, I'm sorry about yeah, the answer to that question is absolutely. What we're seeing is I've gotten calls on the hotline from agents asking that question, but after the fact, unfortunately. They're saying that they've gotten into trouble now because when a buyer discovers that they have an ownership interest in the property that's not been disclosed, now, that's certainly an issue. It's an issue if you are the listing agent and the buyer is still represented. It's even a greater issue if you acting as a dual agent and you're representing the buyer and don't inform your buyer. Your fiduciary obligation would be to do so, right? That in fact you have an ownership interest. And what happens as a result of that? Well, there's a claim made to the Department of State. It's clearly a violation of Article 12A. Disclosure would have necessarily should have been made. It could affect the transaction. You could be subject to litigation. It could throw your commission could be in jeopardy because of it. So a lot of things could happen. I think we all know if we've been doing this long enough. And I say to clients and I say to agents, your three rules of real estate may be location, location, location. My three rules are disclose, disclose, disclose. You could never have enough disclosure. Whenever you're not sure, err on the side of caution and disclose it so long as it's not breaching some confidentiality with your client.
And I think another disclosure that agents or salespersons need to make in these situations is before you list that, probably disclose to your broker. I mean, you got to find out what is your broker's office policy. Some brokerages may not want you to list, your own property or a family member's property. They may even have issues with their errors and omissions policy that prevent that. So before you are handling a transaction that you have a personal interest or a family member has a personal interest, you should absolutely speak to your broker before you handle negotiations or take that listing.
In fact, I got a call last week, Patrick, on the hotline from an agent saying that she wants to sell her own home as a FISBO and not put it through the office. And my answer was, listen, again, that's a question of office policy. You might have signed some type of agreement with your broker, or that in fact, all anything that you sell or buy has to be done through the office. So, it's not a question that I can answer, that we can answer as attorneys. I have to turn back and say, what is your policy? You need to discuss that with your broker manager.
So the next question I just put up, and I think we sort of answered this already, but in terms of disclosure that I would need to make if I'm representing a family member in a transaction, it's the same thing. It's disclose, 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 and actually Code of Ethics, Standard of Practice says you have to disclose a present ownership interest. That present ownership interest includes a lot more than just yourself. It's yourself, a member of your family, immediate family, your own firm, your brokerage, an agent in your brokerage, or even an entity that you or your family have a legal interest in. So, it's a wide net where you have to make that disclosure, and it's whether you're selling or buying. All right. So, next question, Alan. In those situations, is when do you recommend that disclosure taking place?
Well, keep in mind that, it depends who you're talking to, but if you're talking to a client, you talk to a customer, I think the sooner that you do it, the better it is for you. I think that when negotiations are starting, if you haven't done it by then, it's too late. The person who you're talking to, understanding that you have an ownership interest, or you're representing a son or a daughter in that, may feel uncomfortable negotiating with you. Rightfully so. I think that, we look at it internally and we say, how would I feel about that? Maybe the person doesn't care, but I do think it's important to disclose it upfront, clearly before you're negotiating. But I do think too, if you're going to take a buyer as a client, right? If you're choosing to do dual agency, which I think is extraordinarily fraught with danger in this situation, it's not before negotiations. It's at the time that the buyer is becoming your client, prior to having that agency disclosure signed, prior to taking that buyer on as a client. You need to disclose that. I think a buyer client, any place, would be hard pressed and to feel comfortable working with you as a seller who happens to be the agent as well on the listing side. Anyway, that's just my feeling on it. So.
All right. We're gonna now move to something a little bit different, and this might take a little bit of time. We're actually now we're over a year past the rules from the NAR settlement that went into effect about no compensation being on the MLS and the requirement of a written buyer agreement before you tour a home with a buyer. But I know you still get a lot of calls about what agents should be doing, what are best practices. So let's just talk really about what best practices should listing agents be following post NAR settlement. What do you think the most important things are for the listing agent to be doing?
Without a doubt, Patrick, the number one question or questions that are being asked, other than the Fair Act and its
We'll get to
impact
that.
to those of, outside the New York City, would be this. And we could spend 2 3 hours just talking about this, and maybe we will. I think maybe we'll come back and have a more robust discussion on this. But both sides of the transaction, in my opinion, post NAR settlement, need to do a lot more work now. The listing agent who's sitting with Mrs. Monicati taking the listing, at the past, when in fact there was a requirement to compensate to put it on the MLS, and that's no longer the case. And we know that there is an affirmative obligation for the listing agent to disclose to the seller that commissions are not fixed by law, and that there is no obligation for the seller to, in fact, compensate a buyer's agent. there should be an explanation to the listing to the from the listing agent to the seller that even though you're not obligated to compensate, don't be surprised when offers do come in on your property. Don't be surprised if the offer includes compensation to the buyer's agent. That discussion needs to be had at the time of the listing, not when it happens 3 months later and an offer comes in from a buyer who's asking for compensation to their buyer's agent. Your listing contract says that the commission amount that you're putting in is specifically for the listing broker, the listing broker's compensation. And that compensation is not being split or shared. That is the amount that you're being compensated. Nevertheless, the buyer's agents in our market very likely will be asking for compensation. And it's incumbent on the listing agent to inform the seller when they take the listing to expect that to happen. It doesn't mean that the seller has to compensate. It's all part of the negotiation process. The listing agent is going to analyze all of the offers coming in with the seller and see which offer best for the seller. But at least the seller is made aware up front that that could happen. On the buy side, more work, a lot more work is necessary, I believe. And clearly, I think we can say with certainty, if you're a buyer rep, you're doing a lot more work these days, having to explain the buyer representation concept to the buyer client, what that means, what the compensation will be, who's paying that, how that's going to play out. I had a call couple of weeks ago from an agent who said, I work with this buyer. They're very nice people. I didn't want them to have to pay me. I made sure they understood I was being paid. I was going to try to get my money directly from the seller. So I put 0% in the buyer rep agreement. Um, did I do the right thing? My answer was that you're a charitable individual. It's nice to know that you're working for free, and that the buyer will be very thankful to know that you're not being compensated and the buyer's not going to have to pay you because now by putting 0 in that box, you cannot collect any commission from either the seller or the buyer. The agent was flabbergasted. How can that be? Are you telling me I'm not going to be paid? I said, I'm assuring you, you will never make that mistake again. But clearly, this has to be explained to the buyer. Compensation is discussed with the buyer, how that's going to play out, and I think it's important that that be explained.
Yeah, I mean, I can't emphasize enough whether you're using LIBOR's forms or your office has forms that you're required to use, you need to understand them. You yourself should be, conversant with every term in there, understand every term, and be able to walk the seller or buyer through each term. Because, what we've tried to do in our forms is it almost walks you through how the transaction is going to unfold. And if you can do that with the seller, with the buyer, then there's nothing hidden. They understand everything. It's clear. You're not going to have these issues pop up, like Al said, where a seller is going to suddenly find out 3 months later that buyers are looking to get their agent compensation paid by the seller. So walk one, understand it. Two, make sure that in that listing presentation, in that buyer presentation, walk them through the terms of the agreement. Not only does it protect you, but from what I've heard from those out in the field that I've talked to, when they do that, they get that listing, they get that buyer because the client or prospective client says, this person really, they know what they're talking about. It all makes sense to me now. So it protects you and also I think helps you get more business. So
And let me tell you I can't tell you how many agents call me from the closing or post closing telling me that they weren't paid. They're the buyer's rep, but they weren't paid by the seller. So I go through it with them. I say, well, let's talk about that. So when you made the offer, did your offer include compensation back to you? The answer was yes, it did, but it wasn't necessarily signed by the seller. And then that offer is presented The offer is accepted. I asked the agent, did you prepare the term sheet or the deal sheet? The answer I'm getting is, well, the listing agents do it. I don't need to do it. So I didn't get to see it. Well, it winds up that in a lot of these cases, the term sheet did not have the buyer rep compensation in it. So when the attorneys got the documents, they didn't put it in the contract of sale. So it's not in the contract of sale. It's not in any document that the seller has signed. And the buyer, as an agent at the closing, is expecting to be paid. And the seller turns around and says, in some cases, I never signed anything. I never agreed to pay you. There's a form that we have that we suggest that you send as a buyer's rep to the listing agent when in the negotiation and the offer and acceptance, the buyer's rep is being compensated. This is a document that's supposed to be signed by the seller confirming that payment is coming from the seller to the buyer rep. Granted, sellers may not sign this. You need to send it by email from your email to the listing agent so you at least can show the paper trail. But that isn't enough. After you've sent it, you may not get it back signed. You need to know as a buyer rep that your buyer and your buyer's attorney are making sure that this is in the contract of sale. How do you do that? You simply send an email to the buyer and the buyer's attorney indicating with a copy of that form that you sent to the listing agent, informing the both of them, the buyer and the buyer's attorney, that your compensation, either in whole or in part, is coming from the seller. Why is that important? Well, it protects the buyer because the buyer in their buyer rep agreement said they are compensating you X. You might be being paid that fully by the seller. Isn't it in this buyer's best interest to have that in the contract so the buyer doesn't have to pay you that money? It's important that you inform the buyer and the buyer's attorney because the buyer's attorney has a fiduciary obligation, just like you do to your client, to protect their buyer client, to make sure that their buyer client is not paying more for the property to the seller to be able to pay the buyer rep. And at the end of the day, if that money is not being paid, their buyer is paying more to the seller and now has to pay the buyer rep because of the buyer rep agreement. You need to protect your interest. You need to protect the buyer's interest as well. Send those emails. You need that documentation.
Yeah, buyer's agents have to be in constant communication with that buyer's attorney, send that buyer's attorney a copy of the offer that was accepted, and make sure that they know that if there was seller paid compensation, it's got to be in that contract. I just had a discussion the other day with someone and said, "Well, it was in my offer. That's good enough." No, it's not. Like I just I think we have to start really thinking, well, get away from that old school of thought. And the reason why it was maybe acceptable in the past was because the compensation was in the MLS, and that was the agreement to pay compensation. It's not there anymore. There is no agreement. You need to have an agreement, and the best place, if it's coming from the seller, to have that agreement is in the contract of sale, without question.
Listen, as a buyer's attorney, when I do the transactional and I do it's the bulk of my practice, I have more work. It shocks me when I hear attorneys say they don't get involved in this. It's not their job to get involved in this compensation, buyer rep agreements. It's absolutely their obligation to be involved in this. When I work with the buyer now, I have a lot more work. The first question I ask the buyer is, how many of these buyer representation agreements have you signed? I need to see them. Were they exclusive? Were they non-exclusive? They're buying property now with a particular agent working for them. They might have signed an exclusive with another agent 3 months ago. That's going to bind them and forcing them to pay a commission if they don't go through that particular broker. I need to see those forms. And after all that is done, in my contracts, in my riders, it says the seller will be paying the listing broker X and the seller will be paying the buyer's broker Y, if that's the deal, because I want it in the contract As a buyer's attorney, I want to make sure that my client is being protected, the buyer, and paying more money to the seller so that they can, in fact, compensate the buyer's agent. At the end of the day, I don't want my client not getting the money, the buyer's rep not getting paid by the seller, and on top of that, get sued by the buyer agent because they signed a buyer rep agreement. You need to check it, paper it, email. Don't be afraid to do that.
Agree 100% with that. All right, we're going to move on now to a topic that Al brought up earlier, the New York City Fair Act. I'm going to do like a quick 2, 3 minute overview of what the Fair Act is for those that aren't familiar, and then we'll run through a couple questions that I know Al's been getting about it. So for those of you that aren't aware, the Fair Act, it's the New York City Fairness in Apartment Rental Expenses Act. The main thing that it does is it prohibits landlords from passing the fees of their brokers, the brokers they hire, onto prospective tenants. Went into effect in June, and it applies to all residential rentals and leases in New York City. Doesn't apply to the rest of the state. Al, for a while, was getting calls from people in Suffolk and Nassau
All
saying,
the time, all the
yeah,
time.
I think you still have. I know some of the calls that you have gotten. It's if the property is located in New York City, which includes Queens, any of the five boroughs, this applies. And it's only residential rentals. It is not commercial rentals. So what does it say about broker fees? It actually doesn't just say broker fees. It's any fees. Landlord's agent cannot impose any fee or collect any fee from a tenant related to the rental of residential real property. Also, a prohibition on an agent who publishes a listing for residential real property with the permission of the landlord. So that would be an open listing. So if you have an open listing, which means that it's not exclusive, but the landlord says, "Hey, yeah, you know what? I'll give you, the authority to publish this listing." Same thing applies. You cannot collect any fee whatsoever from the tenant. Um, so right there, can't landlord's agent, you can't collect a fee from or impose any fee on the tenant. You should have a compensation agreement if you're working with the landlord, compensation agreement with the landlord that says you're getting your compensation from the landlord, and that's where you should receive your compensation. Again, it applies to open listings as well. You cannot collect your fee from the tenant. If you're representing the tenant as a tenant's agent and working for the tenant in the best interest of the tenant and the tenant alone, you can collect a fee from the tenant for that work. But you should have a tenant representation agreement. You want an agreement with that tenant. It can be exclusive, it can be non-exclusive. It's going to say what you're doing, what your responsibilities are for that tenant, and it should specify what compensation you are getting to that tenant from that work. Real quick, just about dual agency, the Fair Act doesn't prohibit dual agency. It's still permitted. You need informed written consent of both parties, but the landlord's agent still needs to be paid by the landlord for the services they're being provided or providing to the landlord. That landlord fee cannot be paid by the tenant. And remember, if you're acting in that capacity and you're being paid by both for the separate services you're giving to each, you need consent from both parties. You should have written consent from both parties saying that you are permitted to receive a fee from each for the services you're being provided to each. Just one other point, the Fair Act does have fee disclosure requirements as well. So all listings for rentals in New York City, you have to clearly disclose any tenant fees to be charged in connection with the execution of a lease. And then before the lease signing, the landlord or their agent has to provide the tenant with an itemized written disclosure of all fees and include a short description of each fee. Has to be signed by the tenant prior to signing a lease and retained for 3 years, and a copy has to be given to the tenant. There are penalties. It's being enforced through New York City Department of Consumer and Worker Protection. But in addition to these penalties, tenants themselves, prospective tenants, can bring a civil action, a private right of action. So not only can New York City, ding you, the prospective tenant can sue you and say you violated the law. And you know who else can really enforce this? Well, Department of State. They've said they will. They would view someone who does not follow the law as potentially being untrustworthy. and they can seek licensure sanctions and or penalties against you under the licensing law. So questions, Al, I know that have come up. One I know, and we hate this word, but people are always looking for this workaround. How do I get around this? Well, one, never try to get around the law. I know that's always your advice. Workarounds, if you say that, that's a bad thing. But can the landlord have the tenant just pay the first month's rent to the listing agent? Why don't I just do that?
Absolutely. Listen, here's the point. Absolutely not. Um, the problem I think you have as if you're in Long Island is tenants in Long Island think the Fair Act involves Long Island. So we're finding many tenants who come into your offices saying, I'm not paying the commission anymore. In Long Island, as Patrick said, it's business as usual. So when a tenant approaches you and says, I'm not paying you, I'm not going to do that, then certainly you need to have that discussion with them. Maybe show them the law, show them how it works in New York City, but it doesn't affect any place outside of the city. The I think the most prevalent question I get on the hotline for those who work in the city is, how to get around this. What do I do with the landlord who calls me and wants to give me property to rent but doesn't want to pay me? It's a simple answer. Can't do it. You don't take the listing. Now you don't like the sound of that, but that's the answer. It'd be like putting zero in the exclusive right to buy a rep agreement. You're forbidding yourself from getting paid at all. Why would you do that? So if you get a listing, meaning people get hung up on this listing too. It's not, as Patrick said, if you have the apartment in your database because someone called you on it and you put it in your database, whether it's office exclusive or not, if you have it in your database and you're showing a tenant, the landlord must pay you. Patrick asked the question going into dual agency. We're seeing a lot of that. Oh, if I turn them into a dual agent, I understand I can get paid by both. Yes, but here's the catch. If you have that listing and a tenant walks in your door who wasn't your client before, and you just now assume you could turn that customer into a client for that apartment so you can get paid by both, that's not how it works. You're going to lose. You're going to pay back that money. If you're working with a tenant client because you're taking that tenant to other firms' listings, or you're contacting landlords and managing agents to try to find that tenant an apartment, and you have a written agreement with that tenant as a tenant rep that they're going to pay you, then you can get paid. They're your client. If tomorrow a listing comes into your office for that unit to rent, that's pure dual agency. You do represent both at the same time. You can get paid by both. However, as Patrick mentioned, no part of the tenant's commission can be used to pay the landlord's commission. So if the rental is $2,500, you can't charge the landlord $100 and charge the tenant $2,400. It doesn't work that way. You want to charge them the full amount? Fine. You want to charge them half each? Fine. But you can't use the tenant's money to pay the landlord's commission. The reverse is not true. The landlord's commission can be used to pay the tenant's agent, but the tenant's agent's commission cannot be used to pay the landlord.
Okay. I know there's a lot of questions popping up on this, and we're not going to be able to answer
Just
all
call
of
me.
them.
Call me on the hotline,
Yeah,
but don't call me the
call the
next two
hotline. But
hours.
just
That's
so
all I'm
we're
saying.
clear, New York City is the five boroughs. It does include Queens and Brooklyn, Manhattan, Bronx, Staten Island. So that's what we're talking about here. There's a lot of questions could this come to New York State? Will it come to New York State as a whole? I think it may. I mean, not to go too far into the weeds here, but the New York State Governor's office did put a brief in, a legal brief, when there was litigation over this, saying they thought the law was good. They had no objection to it. So that could be a signal that, and there's been some proposals in front of the New York State legislature to try to bring this statewide, which is really why it's important for all of you to be involved with the state association and try to lobby your legislators. If you don't think this is a good idea statewide, you need to let Albany know that. But right now, it's only New York City. It is a New York City law, not a New York State law. Couple other questions. I know you get this a lot, Al. What about the Fair Act and vouchers? Does the Fair Act prevent a landlord's agent from accepting a broker fee from a voucher program?
I wish we could answer that more affirmatively. NYSAR and REBNY acted together to send a request for that confirmation to get an answer that they never did. Listen, the statute is clear. Landlords, if you have the listing, you're supposed to be paid by the landlord. My suggestion, if you're working with the voucher recipient and you're the landlord's agent, contact the social worker on the voucher, contact the program, communicate with them. Say, look, we have the listing. We are the landlord's agent. This is a voucher recipient. Will the program compensate even though we are the landlord's agent? When you're speaking with the social worker, if the social worker, get their email address, confirm that in an email so you have it in writing. That's the best you can do under the circumstance.
Yeah, I see Marilyn has a comment. We don't have a clear answer. And the answer is, yeah, we don't. It's not addressed in the law. A lot of times this is what happens. Legislatures pass laws not really appreciating what the consequence of the law will be. And it's not until the law is put in effect that you see issues like this come up. But I certainly agree with Al that if the program does make the offer to pay, you absolutely want to get the program's position documented in writing. And the other piece is just never, you should never directly ask the tenant for a fee or say, I need your voucher program to pay the fee. I mean, I think that then certainly gives the appearance that you, as the landlord's broker, are demanding that the tenant make some kind of payment. So hopefully we will get some more guidance and clarity on this. And when we do, we'll certainly let you know. One other, I think you covered this, Al, but can the tenant's agent share commissions received from the tenant with the landlord's agent under the Fair Act?
And the answer was no.
Right.
Again, the reverse is true. Landlord's agent commission, you could split with the tenant's agent. The reverse is not true. No part of the tenant's commission can be used to compensate the landlord's agent.
Okay. So we're gonna just talk, and I'm gonna give, again, like a two-minute overview just on some fair housing best practices. This is not intended to be a fair housing course, but just some reminders for fair housing, and then, lead into some questions I know that Al gets regularly through the support center. Oops, I just skipped ahead one too many. And we'll give you these slides, but these are just some best practices to avoid fair housing and concepts. That the one uniform thing that everyone will always tell you is treat everyone equally. And it's very easy to say that. It's another thing to actually do that and practice that. And the way you need to do that is build a system. If you do that and have a system where you're asking for every single person that walks in your office the same questions, the same documents, you follow the same procedures for everyone, you really then don't need to know the protected classes because in essence, you are treating everyone equally. And that's why I say the real main concept and point of emphasis in fair housing always has to be the system, and make sure that you have one so that you do treat everybody equally. And the number one thing you're going to look at is financial criteria. It's does somebody have the financial ability to rent this property and to buy this property? A couple other points, just, these are common sense, but they all go back to a system. Do you have a systematic method of checklists, forms, templates? And we mentioned forms at the beginning, in terms of walking through the seller and buyer. Do you give those same forms at the same time to every person and explain them exactly the same way? That if you do that, you're well on your way to never having a fair housing issue. Keep good records. You always want to give objective information to the consumer about the property. not about, the people that live in the neighborhood, the types of buyers that may come in. Focus on the property and let the consumer establish those geographical boundaries as far as where they want to live. Give consumers a variety of choices. Give all consumers the same choices. Number eight, again, it gets back to that system. Do you greet everybody the same way? Do you follow up with everybody within the same time frames? You need to make sure that you have a system in place that allows you to treat everyone equally. One area that we get a lot of questions, or Al gets a lot of questions, and I know I do too, and we've put a major point of emphasis is lawful source of income when it comes to fair housing. Reason why is it is still the number one area of undercover testing in New York State. Al's been in meetings that I've been at where Department of State has said, this is the area that we're focused on, that we treat extremely seriously, that lawful source of income violations, if they happen, they're looking not necessarily at a fine. They're looking at your license, whether it's suspension or revocation. So it's something
And
that,
Patrick, if I could cut in on that, I'll tell
yeah,
you right
go
now,
in.
because I do the
100%.
hearings on it. It's very simple. If you screw this up and you deprive someone who has a voucher, if you choose to litigate it and take it to the administrative law judge at the DOS to challenge their position, you will lose your license. You'll be revoked. If you agree not to go to trial, but you'll consent the fact, look, you got me, it was a mistake, I did it, you are looking at least 4, 5, or 6 months suspension. That's what they're doing right now. You will be suspended or you will be revoked. There is no middle ground anymore when it comes to vouchers. It's that simple. The problem is, as Patrick mentioned, those of you who do rentals, you know that it's a tough business because you're getting inquiries from hundreds of people at a particular time. And the problem that you have is if you look at those emails or text messages, in between, some of them are writing, "Hi, I'm Al Fazio, I have a voucher." And you don't respond to that person. The position they're going to take is you didn't respond because you saw the person has a voucher. That's a tough position, though. You need to be very attentive to this so that and you say, how do you respond to every single inquiry that's being made? I do think that you have to be aware that when people are writing the fact that they have a voucher or they put in that they are a member of a protected class, you need to go out of your way to respond, in my opinion, affirmatively and say, look, be happy to help you, not a problem. We just need to go further. But not responding, unfortunately, the fair housing agencies are looking at that as you saw that the person is a protected class, you chose not to work with them.
All right. So we have up here what's lawful source of income. If you've got questions about this, we've offered courses on this. Go into depth on this more in the legal update course that I provide. But it's no different. Lawful source of income is no different than any other protected class. So you're not going to turn away a prospect because they receive a voucher. It's just like I'm not going to turn away a prospect because of the color of the skin, the race, the religion they practice. It is the same thing. It doesn't matter where their income comes from. So I get back to the system, the procedure. No matter who calls you, whether they have a voucher, they don't, you're asking the same questions. Where are you looking for an apartment? How many bedrooms are you looking for? What's your price range? Stick to that system. Yes, there are some additional questions that you're going to possibly ask when someone says they have a voucher. You're going to want to get a copy of the voucher, the name of their caseworker. You're going to want to find out more about their program, but you're getting back to them in the same time frames. It's just like you wouldn't if somebody called and said, I'm this race, I'm this religion, you're not going to treat them any differently. And that's why I get back to the concept of having that system. Al, this question, I hope everybody knows the answer to this, but what should I do if an owner refuses to accept vouchers? I go on a listing presentation for a rental and the owner says, you know what, Mrs. Manicati says, I just don't want anybody with a voucher in my apartment. What do you do?
Patrick, if they do that at a listing presentation, that's great. The problem I'm finding is we're seeing the same thing on the listing sales side. Listing agents aren't doing good enough job informing the sellers of everything they need to know that's going to happen in the transaction. You have an obligation, an affirmative fiduciary obligation to the landlord client you're working with to tell them, Mr. Monicati, we are going to be bringing, you understand there's fair housing laws and protected classes. We're bringing everybody to your unit, including those who have a voucher where they're going to meet the rent. Or there might be a voucher that allows them to pay additional money out of their own pocket if the program allows it. As soon as the landlord tells you that's not what I want, it would be the same thing as the landlord saying to you, I don't want somebody because of the color of their skin. I don't want somebody of a certain religion. The response is exactly the beauty of what you do is the answer is exactly the same to every single question involving fair housing. People hear the word voucher and they don't think that it is as egregious as someone saying, I am not going to accept someone because of the color of their skin. There's no level of priority. It's all discrimination. Whether it's, class 1 or class 16, it's irrelevant. Once someone says to you, they will not will not accept somebody because they're a protected class. HUD takes a position on this. Two things. Educate the consumer. Chances are Mrs. Monicati may not be aware of the law. Explain to them what the law says. Educate them. If after educating them, they refuse to accept, will not accept that person, you only have one choice. Extricate yourself from the situation and say, I can't take the listing. Have a nice day.
I see a couple people in the chats and they have their hand up, and I understand that we've got a couple hundred people on, so we're not going to be able to let people come off. And if you've got a question that we're not
Call
able to answer
me.
in the
Call
chat,
me on the
call
hotline.
the
Let's
Legal
talk about
Support
it.
Center.
Not a
Um,
problem. Yeah.
you can also, I'd encourage you, we've got other courses coming up. Take the free legal update course. In that one, I certainly people will know I stick around way past the end of the course to answer questions. But I just want to make sure we get through our material here because we only have about 5 more minutes. Al, this is one more question about vouchers and credit scores, credit checks. Can the landlord require a credit check or certain credit score for voucher holders? I know this
So the
question.
question is maybe, and maybe because the answer is based on if the voucher covers the rent, you can't do a credit check. Assets irrelevant, income is irrelevant, credit is irrelevant if the voucher covers the rent. If the voucher doesn't cover the rent and the program allows the recipient to pay the additional money out of pocket, you can do your checking based on the proportion amount that they're paying out of their pocket. Do you understand what I'm saying? So that if the rent is $2,500 and the voucher covers $2,000, you're not doing the checks as if it were $2,500. You're doing it on the $500 that the tenant's paying out of pocket. And real quick on this, don't assume that the program will allow the recipient to pay out of pocket. That needs to be confirmed. So many tenants believe that they could pay the additional money out of pocket, but the program might have qualified them assuming that they didn't have that money available. So you need to make sure that if the tenant's paying some money out of pocket, that is cleared with their social worker. Check with the voucher as you would with the question of the Fair Act, whether you can accept a voucher if you're a landlord, and get it documented in an email.
All right, we've got a couple more really quick topics. I want to just shoot through advertising very fast because Al, what is I get a complaint against me. I'm an agent, right? You complain against me. I represent. I did nothing wrong though. Your complaint. You're just angry at me. You think I did a bad job, but your complaints are totally unfounded. Does DOS just say, "All right, great, Patrick's good. We're done with him"? What else what happens in that situation?
The DOS will investigate every single complaint, whether it has merit or not. It could be something that's completely off the wall because a tenant or a buyer thinks it's relevant to them. Every every complaint is investigated. And the reason is, and I'll say this, probably 70 to 80% of all the DOS work that I do results in a fine that's got nothing to do with the substantive nature of the complaint. Once you get that complaint from an investigator at the DOS, they've already gone onto your website. They might have looked at all your email correspondence with the complainant, and they're going to see if, in fact, your licensing status is correct, if your name is correct, if you have this, if your website has the disclosures that it needs to have, as far as fair housing disclosures and reasonable accommodation disclosures, it's got to be there. So by the time you get that complaint, chances are the DOS has already found violations, mostly with advertising that you're doing. The substantive nature is secondary. And as I said, most of the time when I resolve these issues, it's got the payment that's being made by the broker is not because of the complaint, it's because of what the investigator found regarding your advertising.
And in most instances, from what I've seen, the consent orders that come out from DOS, they have people dead to rights. Majority of those consent orders that they reach every month are on advertising, because it's really clear cut. So the guidance that I would give all of you is go on our website. We have a whole page devoted to advertising, but you will find there's a DOS checklist. It's what DOS uses when they get complaints. They go down and say, all the rules for business cards, for websites. Do your own audit. Because if you're ever brought in before DOS or DOS does their own random checks of advertising, it's very easy to comply. Doesn't take a lot of effort. So just compare your own advertising to the DOS checklist. We'll give these slides to you. Just these are some of the easy fixes
You
about
know
making.
what, Patrick, if I could real
Yeah,
quick on this, I think
jump
one of
in.
the
Sure.
biggest things I see is this. A lot of your websites, when you first go on it and it says about us, it has pictures of all the agents with their name on it. You click that box, it says Patrick Fife. I click the box and then it tells me Patrick Fife is a salesperson, a real estate salesperson, real estate associate broker, a broker. That's a $2,000 violation. The DOS's position is the licensing status and the name must be accurate on the first box that I'm seeing. If I've got to click the box, that will then take me to the correct information. That's improper advertising. You are fined for that.
And that title's got to be everywhere. That's social media, that's your email signature.
Yes.
Look, I get emails from some of you. I see it's not right. You call yourself a real estate agent. That's not your title on your license. So go and look if you have it on your wall, see what your title is, and make sure that's in all of your advertising, all of your signature lines, all of your social media. You've got to have another couple of quick things. Link to your broker's website. If you've got your own website, even your social media, you have to identify who your broker is and you need a link to their website. I can't, as a consumer, it's also important. I think you're losing business if you don't, because if the consumer has to try to figure out what brokerage you work for, do you think they're going to hire you? Probably not. So really, it's these are simple things that not only will prevent you from getting fines, but save you money. Al also mentioned the links on your website, your fair housing notice. This is on the broker's website, the broker standard operating procedures and the reasonable accommodation and modification notice. Please, again, we've got tons of articles and legal tips on this on the website, lirealtor.com. Check those
Got to
out.
be above the fold. It can't, if I have to scroll down to see those, that's a violation. You'll be fined. It's got to be above the fold.
We're gonna just these are I just want to get to one other point, Al, because I know this
Yeah,
is
oh,
something
yeah,
that
this
you
is
and I have
big.
talked about,
Huge.
and this is the vacant land sale scams. Do you get a lot of calls about this?
Well, Long Island on the East End, it's rampant. Vacant property, people are getting phone calls. Here's the point. This is a major concern. You don't want to be sucked into this. I've heard people at the closing tables, attorneys even are defrauded by their own clients, or they think there's a client seller when in fact they're not. If somebody's contacting you and says they want to sell vacant land or any land, but they can't communicate, they're not going to communicate by phone, they can only do this by text, that should set off your emergency bell in your mind saying there's something wrong here. You need to get verification, who the seller is, identify themselves. Look, these scammers are pretty good at what they do. Obviously, they can make up fake IDs if they want to, but you're going to need to show that you verified that the owner is who the owner said he or she was, because of the number of scams that are going on. You're on notice of this. It is a major problem. And I think vacant land tends to be the primary concern. So as soon as you're getting a call from someone who wants to sell vacant land, your antenna should go up immediately. You need to do a little bit more due diligence to make sure the person talking to you is in fact the owner of the property.
Yeah, I think you told me the other day someone called and it wasn't even a question about whether they were being scammed, but they were talking about a vacant land issue and they said, "Well, I had gotten this listing through a text."
Yes,
You're saying, wait a
text.
second. Well, let's back up. Did you ever have a meeting with the person? So my number one thing is demand that you either have an in-person or a Zoom meeting. It's not a fair housing violation. Just make it your procedure that on a vacant parcel of land, you always require an in-person or Zoom meeting with the owner or the seller before you take that listing. And you want to do all the other things, get identification. But if you do all of that, you've at least taken the biggest precautions you can to make sure that you're dealing with the legitimate.
Agreed. Agreed.
All right. Al, thank you. We're at the 1 hour mark.
Wow, we finished already?
I think we could probably do a session 2, 3, and 4 if we had enough time. So I will.
Patrick, I think we're going to go on the road, you and I. We're going to take this on the road, make it a road show. And what do you say?
I'm for it, and I hope you will come back and do this again for us and in other sessions, and maybe we could do a couple live sessions
We look
in
forward to it.
each
We
one of
look
the
forward to it.
counties as well. So
Absolutely. Look
thank you,
forward to
Al.
talking to you. Look forward to talking to many of you.
Yeah, and if you do have questions, please reach out to the Legal Support Center. And I'm going to later on give you some other resources that I'd like you all to take a look at. So, if things that we provide you that can help answer a lot of these questions. So you don't have to call Al, but certainly if you need to, reach out to him. So thank you again, Al. Appreciate it.